the first to know in Nsem-Pii TV.
Attorney General Yura Dr. Dominic Ay3de etimi atabiri kwabena edubuahen ene ne yere ede won akwako piemu ewo court ni nyina sika bi a egi se afa won ensase na sede amamoni mu no Nsem-Pii TV yetai ebremo constant update about edubuahen case no ene baby a eno ekeka ko na ekame se since our case court to the anytime edubuahen na lawyer for bekwa akopiemu ewo court bi asem bia bon edebekwa akopiemu court bi na court no abo ede atoagu impo evidence ewo se eba na court no etimi ehwe na odi gina so na ode ka asem no court no etimi ebo asem no egu me no ka se de baby asem no ekeka ko no kwabena edubuahen ene na lawyer for hu se 1 and 1 amount tema one sha baby a case ni be kwa kopie no na enye me no ka say de bon etimi atabiri asem no e de akwa kopie mu ewo Supreme Court na Paul e de ho update abaye nkonti
big matter. Kwabena Edubuahen and his lawyers are concerned about the demeanor of the judge at the High Court. They are alleging that the judge is not they are alleging that the judge's role is not being played the way they expect it to be played. So Kwabena Edubuahen here and his lawyers have brought legal action against the judge, and tomorrow the Supreme Court will be hearing the application inviting the courts to endorse their suggestion that the judge be removed and the new judge placed there. It's part of legal procedure that you can ask for the judge to be removed and another judge placed there if you feel that the judge has exhibited bias, unhealthy bias against you one way or the other. But you have to cite cogent reasons why you think the judge has done so. And in the affidavit attached to the writ, Kwabena Edubuahen cites those things. Let's look at them right here at the beginning. This is this is the Attorney General, the Dr. Dominic Ay3de, the learned attaching counsel for Kwabena Edubuahen, and this Deputy Attorney General Nsem-Pii. All three of them very critical to the matter. Now, Edubuahen seeks an order of prohibition against the High Court judge in the matter of the Republic versus Kwabena Edubuahen. That's the way they say it in law. He's looking for an order to prohibit the judge from continuously sitting on his matter as a High Court, as a trial judge. They want the Lord Chief Justice to change the judge. If the panel of Supreme Court tomorrow were to agree with Atacha, then the Lord Chief Justice will have a duty to remove the judge and place another person there so that the trial can continue. So what are the reasons that Kwabena Edubuahen is given or is asking for the courts to agree with him? Now, these are the summary of the reasons, and we'll go into the details in a minute. Reason number one, Kwabena Edubuahen and his lawyer said that the High Court judge has shown bias by holding court sittings with the prosecution present while Edubuahen was yet to be brought into the courtroom. They are alleging that. Two, they say the High Court judge has shown bias by insisting that he continues with the matter while there is a pending appeal against his decision. We'll explain this in some detail in the next page. And then number three, it says the High Court judge has shown bias by preventing Edubuahen from having access to important evidence needed for his defense. So the High Court, so they are saying that the High Court judge constituted court at 4:30 p.m. They were not aware. They were bundled into a car and sent to the court. By the time they got to the court, they saw the Deputy Attorney General and the Attorney General suggesting that these important prosecutors were aware and that they, the other side, were not aware. They believe that is offensive to the Criminal Procedure Act 30, I believe. The second one, they are saying that the High Court judge has shown bias by insisting that he continues. So normally when they bring an application before a High Court judge, he can have a decision on it. He makes his decision. If the parties don't like it, they go to the Court of Appeal or the Supreme Court for a review of that decision. Now, they're saying that whenever that happens, typically the judge must stay the proceedings and wait for the court, especially if they are saying that without this matter, we can't move on to defend ourselves. The judge says, I don't mind, go ahead and defend yourself. But if they sue, as they say, they sue upstairs and they're asking for a judicial review on the matter, typically the judge should hold, but they say that the judge says here, he says he's not willing to hold. Okay, so let's get into the details of the grounds. Ground one, which is ground one, is the High Court judge has shown bias by holding court sittings at an odd time. This is the case. On 30th April 2025, Angela J. Boateng, Charles Edubuahim, and Mildred Donko and their lawyers were invited to meet officials of the Economic and Organized Crime EOCO. But after a 2-hour wait, they were unexpectedly detained by armed EOCO personnel and taken to the High Court, despite protests from their lawyers, Samuel Atachia and Kwame Osei-Asare and Peter Osei-Asamoah. They were ushered into General Jurisdiction Court 10, that's a courtroom, where the Attorney General and his deputy were already present. The lawyers, caught off guard and not formally dressed for court, were served with a charge sheet and prosecution facts that had been filed earlier the same day. In violation of legal procedure requiring prior notice, it will mean that the charges were filed and the court made aware and made to sit the exact same day. The presiding judge, His Lordship John Eugene Nyante Nyadu, proceeded with the arraignment despite objections, and the group exited the courtroom at about 4 p.m., at about 6 p.m. Now, Kwabena Edubuahim is saying that this is untoward, this is not part of the legal procedure. You don't surprise an accused person by asking him to come to an investigative agency, Yoko. He's at Yoko for 2 hours. He finishes, hey, come and sit in this car. He sits in the car, they are put in the car, and they are sent to a courtroom. Then the Attorney General is already there, the judge is there. It's past 4 o'clock, normal time for the court to close, but this judge was sitting waiting for them, and then they served them with a charge sheet, etc., etc. So that's ground one. Ground two, that the lawyers of Edubuahim filed an application praying the court for an order directed at the Attorney General to disclose all the pages of evidence required. This included some pages of a bank statement produced by the Attorney General, as well as evidence of certain procedures that are used by the national security architecture. The application was because some of the pages of the documents provided by the Attorney General as evidence against Edubuahim had been deleted and could contain important evidence to prove his innocence. Further, the court's order for national security to disclose its procedures would have aided the defense, show the court that what Edubuahim did was standard practice in national security architecture and was not theft. So on this one, the Attorney General brought a document to the court to prosecute Edubuahim. It's a bank statement from one of the banks. Now, the bank statement has about 100 pages, but the observation was that about 90 pages were taken out, and the court didn't see it. It wasn't in it. So the Edubuahim's lawyer says, but what's going on? You have a bank statement that has Edubuahim's transactions. It's 100 pages. Put all there. We will show you what you are looking for. We'll show you how it works. But you have taken this substantial amount out, and you are submitting to the court a few documents. I mean, if this is true, it's quite bizarre. If it's true, it's very, very bizarre. You are a defense person. They bring your bank statement, and they've taken some out. How are you going to deal with that? Why should the prosecution be allowed to do that in a democracy and in a normal court practice? So they're arguing against that. That's not correct. I mean, if this is true, this is very serious. Also, they say that the things that you're accusing Kwabena Edubuahim for is a standard procedure of the national security architecture. Bring the national security people in. Let us ask them whether this is not their procedure, whether in 1993 they didn't do the same thing, whether in 2016 they didn't do the same thing, whether in 2011 they didn't do the same thing. And then the prosecution says, no, I'm not going to do that. And they make an application to the judge. The judge says, I'm not going to allow you to do that. It is as if you want to tie his hands behind him and shoot at him. You don't want him to be able to defend himself, because the material that he's going to use to defend himself is within the bosom of the prosecution. Sometimes they call it discovery in legal practice, but Edubuahim is complaining about this as a second ground. The third ground, Edubuahim says that, okay, so on the second ground where they are not allowing him to defend himself, he's relying on a recent case of Republic versus Bafuboni, in which the current acting Chief Justice ruled as part of the matters, and it was said that they should allow the prosecution should give to the defense anything that the defense needs that will be needed for the evidence in aid of the defense case. Prosecution and the court should allow the defense to get everything that the defense needs, even if they have to get it from the prosecution, which will allow and aid the defense of his case. So Kwabena Edubuahim cites this as the reason why he thinks that the judge should comply and allow them to get the full document of the bank statement and also the national security procedures. They should bring them to the court. Now, on the third ground, he says that upon refusal by the court's order, the Attorney General to provide full disclosure, Edubuahim's lawyers appealed the decision by the judge, insist on continuing. Edubuahim appealed the decision by the judge. I appealed the decision, but The judge insists on continuing the trial despite a pending appeal before the Court of Appeal. This is all on the backdrop of the judge acceding to request to the Attorney General to deal with certain matters earlier than has been fixed for determination in the court. So this is very, very, very concerning. Here, Dubois' lawyers are saying that based on the fact that the judge says he will not allow them to get the full bank statement, they filed an appeal to the Court of Appeal, told the Court of Appeal that, look at this, we need this to defend ourselves, but the High Court judge says that we are not entitled to it. Now, whilst the Court of Appeal is preparing to hear the matter and give a decision one way or the other, the High Court is continuing with the trial. That whether you have it or not, I'm moving on. I'm going on with the trial. He may go on the trial and get to the end of the trial whilst the Court of Appeal is yet to bring the decision down. So they are saying that, no, let's go to the Supreme Court and say that based on all of these demeanor findings, we believe that this judge should be prohibited from continuing to hear the matter. The Supreme Court hears the matter tomorrow morning. Good luck to all parties. But we hope that the democracy is built as a democracy. It's not built as a democracy of an oligarchy, or it's not built as a democracy of some feudal state. Democracy is democracy. Transparency is important. The judicial strength is important. People must have the right to defend themselves. All of those ethos guaranteed by the 1992 Constitution must be very important. If a person is guilty, he's guilty. But let's not be hearing these things from the court, and let's hope that these things are not true. The Supreme Court will have their decision to make tomorrow when all of these matters are brought before them. Let me take some text messages, and when I come back, Fuamoni is here, Sam George, the Speaker, and Mahama Ay3de. Earlier today, Moses Fuamoni's coalition held a press conference, and they were quite straightforward. They said that if within 2 weeks they don't see where the thing is going, it's going to be a problem. Mahama Ay3de's view of the matter is that the bill had died. Oh, sorry, the touch screen is going to come back here. Is it back? Mahama Ay3de's view of the matter is that the bill had died in the 8th Parliament and a new one needs to be set up. The President also said the bill had died and a new one needs to be set up. People think that the bill has not died. I think there's a whole constitutional conversation on it. To the extent that the bill did not fulfill all the stages to become law, it will stand as having been killed by the 8th Parliament, because it has to complete its process to become law. Then it would have been a bill passed by the 8th Parliament. The 9th Parliament cannot pass something that was begun in the 8th Parliament. No Parliament can pass something begun in another Parliament. If a bill is begun in a Parliament and it doesn't see the light of day until the end of the life of that Parliament on the 6th January, 4 years hence of the inception of that Parliament, then the bill dies naturally. So the Speaker has promised that they are going to set the bill again. In fact, in Team Fojo has a new draft. And so they are preparing for it to go through the stages in Parliament, 1, 2, 3 readings in Parliament, with all the adjustments, perhaps a public hearing somewhere, and all the memoranda collected. It will be passed and it goes to President John Dramani Mahama. It is only then that the test for Mahama, whether he wants to sign the bill or not, will accrue. Up until now, there's nothing before the President's desk. But the coalition has started holding press conferences, and perhaps on Thursday we'll interview Moses Fuamoni about it. Also, another small matter. The bill, Sam George is preparing a bill to go to Parliament, the Cyber Security Amendment Bill. That's very interesting. And in the Cyber Security Amendment Bill, he's complaining, there are complaints that there's freedom of speech that is being tampered with. There's massive tampering of freedom of speech by the bill. We are going to check that. On Thursday, we'll come with a full analysis of the conversation. I've seen the video that Kojo Ponkroma.
Now, NA, ya kind varying reports from the High Court. Me pacho wakwaye lawyer ni ewujina ma chairman won to me. A day in the CEO High Court ene.
Yo me dasi. Ye di kan ma me chia me mi yan mo mo ti. E se wa kwa de wa so ye lawyer.
Yes.
Eti abanye hu na so hu.
Anye easy o.
The chair said the last agenda date you. My lady Odase Attorney General Omo value discoveries 1 week before we come to the court. I quite remember say on my feet on the day I argued say the next agenda being the date for CMC meeting. My lady admit here to 10 o'clock in the morning. Because normally, the court will take the motions first. Now, many argument, my lady did not object or accept. And the presumption was that she had agreed with us for the 10 o'clock. Unfortunately, we say, also, she did not record it. And until now, I had normal attendance. Until maybe 10 o'clock, so I came out to say, oh, yeah, the court time near 10 o'clock. And he had come to the court, but had been waiting in the court for me to come, say, about 10 o'clock.
Yes.
And he could do 10 minutes to 10. My court, I call the case, issue bench warrant. And he, now I asked him,
Now, court, not call it case in the time, Bain.
Apparently, he called case, around 9:30 or so. But like I was saying, the business of the day was CMC.
Yes.
And Attorney General was not really with the witness statements, the evidence, the exhibits. Attorney General was not ready. They have not even served us. So, me cry with himself. Because of the inability of the Attorney General to serve us, could date, probably giving Attorney General more time. Until now, the day was not that busy for us. All the same, now SSA should appear. If you could do from 10 minutes to 10, now you call case, what is number that? Until we had to appeal to the registry of the court, my court to reconvene for us to make an argument because the man was in court premises, but in the waiting for me to come for us to go for a 10 o'clock hearing.
Okay.
And he got so good. My commended judge, for today. I don't think the day is necessary, but keep baby, I make a comment here, say, notwithstanding, say, now, what I see, the presumption, say, the Chabaut to me and the appearance.
Yes.
Okay, yes, story, me, I did not through the registry. She advised that the registrar should call back the Attorney General's representative for us to reconvene. And I will also commend the representative of Attorney General, said, on also so, what they said, court plenum. She also came back and we had a court visit and we made our prayer to the court. It was not intentional. Maybe we didn't understand each other and we thought that it was a court. We prayed that the order be vacated, which the court did. Let me also mention, say the court also warned the accused person, said, in all cases, if the lawyer cry is not in, it should be in court. And in fact, 10 o'clock, it must be 10 o'clock, unless the court is on record to have pronounced a different time. And it is an opportunity for all of us as practitioners to understand the system better.
Sure.
And to learn also new things.
Sure.
And
and then the court now sign a vacate bench warrant,
that is correct.
Okay. Now, what me be a CMC, no?
CMC, the Attorney General is ready with.
I don't know ready with Nidia, no. Okay.
Discoveries. Very well. We will prepare to go and to the CMC and subsequently to commence the trial.
Very well. In the next agenda date near Dabain?
Next agenda date near 4th of November.
4th November. Okay.
Yes.
By which time, okay, that will be too short for. And I say, court now order say AG any discoveries not by that time.
Yes, court now order say AG any discoveries good enough time for us to come. Don't forget, if you say, sir, it requires 3 days of time to look at it, come back to start. And I presume, say, a court will expect AG to file between now and the end.
Yes.
So they have been good enough time to prepare for the CMC and also commencement of the trial.
Very well. Very well. Mate, inti lawyer, I think this